Florida families, do you know what happens to your property after you pass away? Most people assume their family can just take over, but the truth is, without proper planning, your loved ones may face probate, a long, expensive, and very public court process. Let me break it down for you. Hi, I'm Stephanie Cruz. I'm an estate planning attorney here in Florida, and I help families protect what matters most and avoid unnecessary legal headaches. Today, we're talking about probate. What is it? How it works in Florida, and how we can make things easier for your family. If you've ever heard someone say you don't want your estate to go through probate, you're about to find out why. So what is probate? Probate is a court-supervised process that happens after somebody passes away. It ensures that debts are paid, taxes are handled, and assets are legally transferred to the heirs. Sounds simple, but it can get complicated very quickly. So when does probate happen in Florida? If you pass away owning assets in your name alone with no designated beneficiaries, your estate will go through probate. Common assets that trigger probate: real estate held only in your name, bank accounts without a payable on death, a POD beneficiary, personal property like vehicles, jewelry, or art. Example, if you own a house in Florida and your will says that it goes to your children, it can't just happen automatically. The court has to supervise that transfer through probate. Why people want to avoid probate? Time. In Florida, probate often takes 6 months to a year, sometimes longer if the estate is complicated. The cost. Probate can be expensive. Legal fees, court fees, personal representative fees all reduce what's left for your heirs. Public record. Everything filed in probate becomes public. Everyone can see who inherited what. The stress. Dealing with courts and paperwork during grief can be overwhelming for your loved ones. Are there different types of probate in Florida? Yes, Florida offers several types depending on the size of the estate. Formal administration for larger or more complicated estates, and summary administration for a quicker, simpler process for smaller estates, usually under $75,000, or when a person has been deceased for more than 2 years. In certain areas in Florida, you can do a disposition without administration, only in very limited cases, like reimbursement for funeral expenses when there are no other assets. So how can you avoid probate in Florida? Good news. With proper planning, you can help your family skip probate altogether. Here's how. A revocable living trust. Assets in trust pass directly to beneficiaries, avoiding probate. Beneficiary designation for life insurance, retirement accounts, and some bank accounts. Name a person, not your estate. Joint ownership with rights of survivorship. The asset automatically passes to the surviving owner. Avoiding probate. Ladybird deeds. A Florida-specific tool to transfer real estate outside of probate while keeping control during your life. Example, if you own your Florida home in a Ladybird deed, it can pass directly to your child when you pass without going through probate. Now, understanding that when I reference child, I mean your 18 and over child. So probate doesn't have to be a nightmare, but it can be if you don't plan ahead. The best time to make a plan is right now, while you're healthy and clear-headed. If this video helped you understand probate better, please give it a thumbs up and leave a blue heart in the comments. If you're ready to start creating a plan to avoid probate and protect your family, send me a DM. Thanks for watching. I'm here to help you take the stress out of estate planning.